Good morning. Happy Monday. Apparently, someone decided to commit arson at the office building where I work, where my office is. And yeah, so it's good times. Luckily, my office wasn't burned up. No fire damage to my office, but there's plenty of water damage. And there's no electricity in the building, which means, obviously no internet, blah, blah, blah. So this is going to be fun. And one of my kids threw up on the way to daycare in the car, so that's also great. So my day's going wonderfully. I hope yours is doing better. So Lane Meyer supporters have brought out Counterman versus Colorado to try to suggest that somehow Lane's probation conditions are unconstitutional. Again, it is inapposite. It doesn't apply. It's the wrong case for the wrong reasons. Counterman versus Colorado, a gentleman who was convicted of violating a Colorado statute on threats. And so obviously right there you should be seeing the difference. First of all, he's appealing his conviction. Lane Myers pled guilty and the time for his appeal is passed. And Counterman was convicted of violating a statute that criminalized threats, not harassment or stalking. So different statute, different things. While harassment can catch threats in it and stalking can catch threats in it, it's conduct restriction. Whereas just pure speech threats are speech. So they're different things, different analysis, and if you're looking at United States Supreme Court cases, it'd be like U.S. versus O'Brien. That's the draft card burning case, as opposed to Counterman versus Colorado, which is a true threat case. There are lots of other true threat cases. They've been well litigated. Work truck fixing fire damage, phenomenal. Anyway, so there's that issue. And in addition, Counterman was not on probation. He didn't violate a condition of his probation. He violated a criminal statute. Obviously, Lane Myers is on probation. He has terms and conditions of his probation. What Lane Myers supporters need to do if they want to make an actual legal argument about why what is happening to Lane Myers is somehow prohibited by the First Amendment is to find a case, preferably an Arizona case, where someone on probation is restricted from talking about someone else or talking to someone else. I mean, the further away you go from the actual facts of Lane's situation, the less compelling the analysis is, the case law would be. But that's really what you want to find. You want to find, or a U.S. Supreme Court case interpreting a state statute or a state probation case where the state has restricted speech in a manner similar to what Lane Myers did. But the problem is that you're not finding them. That's the problem. So these guys are just going far afield, like the Brush versus Nib Arizona Supreme Court case. At least it was in Arizona, so I got to give Lane Myers credit for that. He did find an Arizona case. But as I said previously, it's apples and oranges. One is compelled speech. You have to say this versus restricted speech. You cannot say this. It's like if I'm going to give my kids, like, I don't know, apple pie. Me saying you can't have it is different than me saying you must eat it. If you can't grasp that difference, then please don't comment in my comment section, because I have enough frustration going on today. I don't need to deal with idiots. Speaking of idiots, and speaking of Brush versus Nib, that Peter or Wayne or whatever the hell he's posting under, he has multiple screen names. He said that Brush versus Nib only applies specifically to that one case, that one appellant, Brush versus Nibs. It only applies to them and not to anybody or anything else. You don't get a published opinion if it doesn't apply. If there aren't legal principles in there that can be broadly used, it is not published. There's a lot of cases that aren't published, and if it is published, that means that there is some value in the legal precedent, in the way the court explains the law and how to apply the law. I think he's misreading a portion of it where the Arizona Supreme Court is saying this only applies to the compelled speech portion of this particular statute. It was an anti-discrimination statute. And so the state can still say, no, you can't discriminate as far as like, not providing hotel services or food services or whatever based on race, creed, color, gender, whatever. But as far as compelled speech is concerned, then this particular portion doesn't pass strict scrutiny. So I think he was misunderstanding that. He is one of these people who always says everything very confidently with absolutely no knowledge to back up what he says. But, he still thinks that they settled Fraud or Troll versus DMA. He still thinks they settled that for nothing. Anyway, I gotta go. But he's stupid, and Lane Meyer supporters are stupid. And thanks for watching. Have a great day.